Hello and welcome to Lesson 4 on Bar10's test prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Don't forget to like, subscribe, and ring the notification bell so you can be updated every time we upload new content, which is every day. Okay, let's get right into question number 1 for this group. A motorist was driving on a highway at night. His girlfriend was in the passenger seat. They were returning from a college night class. She was smoking marijuana, blowing it out the open window, and not sharing it with the driver. The driver fell asleep, causing the car to veer off the highway and hitting a tree. Both the driver and passenger were seriously injured. She sued the operator for negligence. The operator filed a counterclaim, asking for damages against the passenger by arguing that the passenger was herself negligent by smoking weed and causing him to fall asleep. Is the court likely to grant the passenger's motion to dismiss this counterclaim? A, yes, because the passenger was not actively participating in a joint enterprise and did not do enough to contribute to the cause of the accident. B, yes, because a vehicle operator is always liable and a passenger cannot be made liable for the driver's actions under any circumstances. C, no, because the driver has properly alleged a joint enterprise situation where the passenger is liable for her share of the negligence in causing the accident. Or D, no, because the passenger was breaking the law, making her negligent per se. You have 10 seconds to consider the answers. If you chose option A, you'd be correct. Yes, because the passenger was not actively participating in a joint enterprise and did not do enough to contribute to the cause of the accident. It's hilarious how the word joint is used in there. I'm sure you caught on to that. But that is accurate because, in fact, the driver did not engage in any activity that would have caused the accident whatsoever. So the argument that she is contributorily negligent or negligent in any way which would have caused the accident leading to any liability is utterly ridiculous. As a result, B, C, and D would be incorrect. A passenger may be found liable for injuries to others in an accident if the passenger's conduct substantially encouraged or assisted the driver's negligence. Here, there's no possibility of that based on the given facts. The driver clearly had a duty to stay awake and drive carefully. Breaching that duty by falling asleep dictates an award of damages to the passenger. Question number 2. Dealer has a car for sale claiming a 30-point inspection, including engine and transmission. Doug goes to purchase said vehicle and he puts a deposit down, but intelligently takes the vehicle to a mechanic for a complete workup. Mechanic notes the vehicle was in terrible condition and had sustained significant damage in an accident and had been repaired but improperly. Mechanic noted the engine was not functioning properly as it was cracked and that the transmission was skipping shifts between gears and leaking oil. If Doug seeks a refund of his monies and cancellation of the contract, although there is an alleged no refund policy, is he likely to succeed in court? Here's your 4 options. A, yes, because the dealer withheld material information intentionally and knowingly misrepresented the condition of the car. B, yes, because the dealer has a duty to give every reason why an as-is car may go bad and to list those reasons on the window. C, no, because the dealer cannot be held responsible for possible damage that the used car may have developed after years of use. D, no, because the dealer is absolutely protected when he sells a used car in as-is condition and where the warranties under the Uniform Commercial Code are duly waived. You have 10 seconds to consider the answers. Correct answer is A, yes, because the dealer withheld material information intentionally and knowingly misrepresented the condition of the car. Answer 1, as a result, is the correct answer. Fraud is the intentional misrepresentation of a material fact or the knowing failure to reveal material information. The test for determining whether a fact is material in a consumer fraud context is whether the knowledge of the fact would have caused the consumer to act differently. Here, the allegation is that there was a 30-point inspection, including the engine and transmission. And that being said, there was seemingly nothing noted with regards to any damages to the vehicle because once mechanic inspected, it was seemingly a surprise that these issues came up, the issue of the leaky transmission and the cracked engine. As a result, B, yes, because the dealer has a duty to give every reason why an as-is car may go bad and to list those reasons on the window. It's a bit beyond ridiculous. any reason. The car could go wrong for any reason. There could be issues with the vehicle for millions of reasons. As a result, listing them would be unreasonable. C, no, because the dealer cannot be held responsible for possible damage that the used car may have developed after years of use. This is missing the point. The point here is that the dealer is offering a guarantee based on an inspection. The inspection would seemingly be inaccurate given the fact that a basic review of the vehicle by a mechanic led to showing that two of the major points of the vehicle which allegedly were guaranteed were in fact faulty: the engine and the transmission. Finally, D, no, because the dealer is absolutely protected when he sells a used car in as-is condition and where the warranties under the Uniform Commercial Code are duly waived. That may in fact be accurate to a degree. If there had been no inspection presented and the vehicle was sold in as-is condition, perhaps that argument could be valid. But given the fact that there is an inspection alleging that the engine and transmission were in working order and a subsequent mechanic review or mechanic inspection that states that both of those statements are in fact completely inaccurate or full misrepresentations, then that is why A is the most correct option of the four. Question number 3. Victim of a crime gives a description of the perpetrator which leads to a rendering of the alleged robber and an arrest. Upon arrest, Jailbird is found to have victim's stolen property on his person. Unfortunately, as a result of unrelated concern, victim dies prior to testifying at trial. Is the court likely to still permit the police drawing as evidence in the case against Jailbird? A, yes, because the police took it and used it to find someone. Therefore, it must be an accurate representation of the perpetrator. The exhibit must be admitted. B, yes, because it is in the nature of the written recollection of the decedent at a time close to the crime, and it therefore has testimonial reliability. C, no, because the defense had no opportunity to cross-examine the witness under oath about the drawing prior to her death, and as such, sketches are inherently reliable in any event. No, because it was drawn up days after the event and is in violation of the best evidence rule. You have 10 seconds to consider the answers. The correct answer here is C, no, because the defense had no opportunity to cross-examine the witness under oath about the drawing prior to her death, and such sketches are inherently unreliable in any event. A composite sketch is an out-of-court statement by a witness, and it is hearsay that does not fall under any exception. Generally, the prior testimony or evidence of a witness who is now deceased is inadmissible unless that witness was in fact cross-examined about the evidence prior to trial. See the famous case of Crawford v. Washington, 541 U.S. 36. Okay, let's move on to question number 4. Two friends took title to real estate as joint tenants with a right of survivorship. The first friend put up his interest in the joint tenancy as security for a $20,000 loan and signed a judgment note. It was later entered as a judgment against the first friend's interest in the real estate. The first friend died a year later. The second friend decided to sell the property, but the mortgagee filed an action to prevent the sale and to enforce his interest in the property. The second friend defended on the basis that any lien on the first friend's interest in the property was extinguished on the first friend's death. Will the court enforce the lien of the mortgagee against the sale of the property by the surviving second friend? A, yes, because the second friend's assent to the judgment lien was presumed by law, and that assent destroyed the joint tenancy. B, yes, because a mortgage or judgment lien against one joint tenant destroys the tenancy and destroys the right of survivorship. C, no, because a joint tenant cannot legally file a judgment note on just the joint tenant's interest, because it would be an unconstitutional interference with the other person's property rights. D, no, because when the first friend died, the second friend became the sole owner due to the right of survivorship, as per the joint tenancy, which is still fully intact. You have 10 seconds to consider the options. Correct answer is D, no, because when the first friend died, the second friend became the sole owner due to the right of survivorship, as per the joint tenancy, was still, in fact, fully intact. A judgment note or mortgage lien given by one joint tenant on his interest of the property does not sever the joint tenancy. The second friend's right of survivorship became operative on the death of the first friend. As such, he became the sole owner of the estate in its entirety. Now let's move on to question number 5. The Mona Lisa is stolen while on tour in a U.S. museum. A painting is supposedly recovered which matches the missing painting. An outside expert was used by the police to authenticate the recovered artwork. Would a court likely accept the authentication of this outside expert? A. Yes, because an outside person may be able to partially authenticate the painting, but he can't say whether it was the one that was in the museum or that was stolen. B. Yes, because artworks and other physical evidence must be authenticated by their official custodian. C. No, granting the objection will simply waste the court's time if the court has to bring in the museum curator and go through hoops to authenticate the paintings. D. No, because the authentication can be accomplished in several different ways that will verify that it is the genuine piece of art in question. Consider the 4 answers and choose wisely. You have 10 seconds. Correct answer is D. No, because the authentication can be accomplished in several different ways that will verify that this is the genuine piece of art in question. The details of the burglary will be covered in other testimony separate from the expert testimony on the authentic quality and source of the stolen items. Authentication is satisfied by evidence sufficient to conclude that the matter in question is what the proponent claims. For example, that a Picasso is indeed a Picasso, or here, that the Mona Lisa is in fact the Mona Lisa. Question number 6. A furniture dealer sold furniture to a young couple with less than perfect credit. They signed a contract that said that if they purchased new items on the account, they would not own the old purchases until the new ones were in fact fully paid off. That provision was in fine print on the reverse side of the papers. When wife lost her job, they had by that time paid for everything purchased on the account, except for one chair they bought a few weeks earlier. The store sued, trying to repossess all furniture ever sold to the couple. Will the couple likely prevail on the defense of unconscionability? A. No, because they might be able to find another store to sell them furniture, which proves that there was no lack of bargaining power. B. No, because the store was nice enough to extend credit, and the couple should be expected to pay for everything before they own any of it. C. Yes, because any time a seller puts terms in fine print, it is proof of bad faith and unconscionability. Or D. Yes, because a combination of factors makes it likely that the court will recognize unconscionability under these terms. You have 10 seconds to choose your answer. Correct answer is D. Yes, because a combination of factors makes it likely that the court will recognize unconscionability under these circumstances. Any one factor is generally not enough, and unconscionability will be found on a thorough examination of all factors that demonstrate a lack of bargaining power, unfair terms, small print, and an oppressive situation favoring the party with the strongest position. Here, the couple was without question in the weaker bargaining power position, as well as the facts, in essence, show that they had paid off the vast majority of all of the items they had ever purchased from this seller. So as a result, their attempt to secure all of the items, some of which or most of which had already been paid for, would likely be deemed unconscionable, especially in light of the small print, the print on the rear of the agreement, as well as the credit situation for the purchaser. Question number 7. Witnesses given several different accountings of a crime over the few years in preparation for trial. At trial, during cross-examination, witnesses impeached with his prior inconsistent statements. Will the court permit prosecution to present prior consistent statements over counsel's objection of them being repetitive and cumulative? A. No, because the witness cannot be rehabilitated once a successful impeachment has occurred. B. No, because it would tend to confuse the jury with too much conflicting evidence. C. Yes, because it is being used to rehabilitate a witness whose credibility was attacked. Or D. Yes, because all repetitive prior statements are important to show the consistency of the witness's testimony. You have 10 seconds to choose an answer. Correct answer is C, yes, because it's being used to rehabilitate a witness whose credibility was attacked. Prior consistent statements are repetitive and improperly bolster the witness's testimony. There is an exception, however, where the prior consistent statement is needed to rehabilitate the witness, where the credibility of that witness was impeached on cross-examination. Let's move on to question number 8. At a crime scene, officer found the right shoe print, noting a specific brand of shoe that was extremely rare and high-end. On searching the closet of suspect 1, single left shoe of the same brand is found, but no right shoe. Is the evidence of the left shoe admissible at trial against the suspect? A, yes, because it is direct evidence of guilt. B, yes, because it is appropriate circumstantial evidence of guilt. C, no, because the shoe is irrelevant and will have no residue or other probative evidence relating to it. D, no, because footprint evidence is highly speculative unless both shoes and shoe prints are offered and authenticated. 10 seconds. The correct answer is B, yes, because it is appropriate circumstantial evidence of guilt. This is admissible circumstantial evidence because it requires one or more inferences to be made in order to conclude that it was the suspect's shoe print at the scene. The conclusion associated with the inference must still be proven beyond a reasonable doubt. Direct evidence is like an eyewitness account. No inference is required. Here, however, there is an obvious inference that's required, given the fact that the shoe was not actually, in fact, the shoe of the scene, but a different shoe. Question number 9. Ralph is charged with rape of his ex-wife, and in his defense, he presents character evidence the victim has filed multiple prior false allegations against former boyfriends when they were breaking up. While character evidence is generally inadmissible, would it be admissible for these purposes under these circumstances? A, yes, because dishonesty at any time in the past is always relevant to a malicious prosecution complaint. B, yes, because even though character evidence is too collateral to be admitted for circumstantial evidence, it is admissible if it is directly at issue in the case. C, yes, because reputation evidence, just like most character evidence, is virtually always admissible. D, yes, because while most character evidence is not admissible, some is, and reputation evidence is always admissible. You have 10 seconds to choose the best answer. The best answer is B, yes, because even though character evidence is too collateral to be admitted, the circumstantial evidence, it is admissible if it is directly at issue in the case. Character evidence may be offered when it is relevant to the material facts of the case, including, as here, when the original complainant is now defending himself or herself against an accusation in civil court of a tort of malicious prosecution, or when the allegations are similar in the sense that the complaining witness is alleged to have made similar allegations in the past, each of which led to perhaps non-prosecutions. This would tend to show a trend on behalf of this particular individual that the individual repeatedly makes up claims such as these. Our final question in this grouping, question number 10. In a comparative negligent state, woman is injured by defendant while she carelessly crossed the street while texting. Driver, on the other hand, was careless in that he too was texting and driving, and at the scene of the accident was issued a citation for texting while driving. Woman sought summary judgment on a theory of negligence per se, given the fact that driver was charged with the use of a cell phone while driving. Would woman's motion likely succeed? A, yes, because the driver had the last clear chance to avoid the accident, which abrogates the comparative negligence law. B, yes, because negligence per se is a final judgment of total negligence against the driver, and it cannot be modified or rebutted. C, no, because the common law doctrine of negligence per se does not abrogate the defendant's right to apportion fault under the comparative negligence statute. D, no, because she entered the intersection without paying attention, thereby putting herself voluntarily and knowingly in risk, and she assumed that risk. You have 10 seconds to choose what you think is the best answer. The best answer would be C, no, because the common law doctrine of negligence per se does not abrogate the defendant's right to apportion fault under the comparative negligence statute. Under the comparative negligence statute, the relative degrees of plaintiff and defendant's fault must be ascertained to determine whether and what amount of recovery is proper. As a result, if you chose option C, you would have chosen the best answer. Thank you again for joining us on Bar 10's test prep, where we aim to prepare you for the bar exam test 10 questions per day. Please like, subscribe, and ring the notification bell so that you can be updated every time we upload new content.